And there, we are now broadcasting worldwide. I'll throw this switch. We're on the record. I'm calling case number 23-012-577-NI, style Hayel, last name ABDUL-MAGID, versus MOHAMED, middle name is ABDULWASSA, last name ALBANA, and Top Hawks, 2 words, LLC, those 2 tort defendants jointly and severally. And our third defendant is Amerisher Mutual Insurance Company. For purposes of argument, oh, my video is not open. Huh. There we go. All right, thank you, Mr. Hodgman. For purposes of today's hearing, I suppose it'll be Mr. Abdul Majid or plaintiff, Mr. Albana, Top Hawks, and Amerisher, in the order in which your client was identified. Caption, I'll take appearance of counsel for the record, please.
Good morning, Your Honor. Justin Haas for plaintiff.
Good morning, Your Honor. Michael Watt on behalf of Amerisher. Your Honor, the litigation involving Top Hawks and Albana has, I don't want to say resolved, but it's been being handled along the lines of our stipulated order setting forth litigation in this case, and their issues aren't in play at this time. Justin, does that comport with your understanding of our agreement?
It is, and Your Honor, I know we haven't been in depth on this case yet. I'm not sure if you had a chance to review all the pleadings, but if I may just have 60 seconds, I can bring up to speed on the stipulated order that we entered into.
Sure, I'm always happy for that. I will tell you, it sounds like a horrible situation, brake repair, and I think the gentleman lost his leg.
You did, Your Honor.
And it is, it's an unusual position to have a plaintiff filing a deck action, but there we are. Yes, November 21st, 2022, accident date. You have the floor, Mr. Haas.
Thank you, Your Honor. Just
wait, do I have appearances from all 3 counsel? I have Mr. Haas, Mr. Awad, and
Your Honor, I'm sorry, I apologize for interrupting, but I want to just, I mentioned this, Mr. Hodgman. Mr. Belize has not been admitted yet. There's a motion up on Friday to have him admitted pro hac vice. So he was just observing today and wasn't intending on entering an appearance.
Good morning,
right, but he can tell me his name. And
apologies, Your Honor. Anthony Belice, and to echo Mr. Watt's comment, I'm just listening in today, and my pro hac vice is up for hearing this Friday, I believe. So I will be.
It might be up today, but we'll get there. Spell your surname.
Thank you. I'm sorry. It's a B as in boy, ALICE.
Belice?
Yes, Your Honor.
And please correct me if I say it wrong.
No, that is actually correct.
I will tell you, we've had 2 Haas's on the docket today. What are the chances?
Not great.
All right. So I have everybody's name. Mr. Belice, you're presently admitted in how many states?
I am just in Illinois, Your Honor. I'm pro hac vice in other states, but just Illinois.
Got it. Is Sullivan still the directory there in Illinois?
Yes, I believe so.
I was admitted in Illinois for a period and then decided, what am I getting for my money? Didn't think of only one case I had there, and that was in federal court, for which admission is not necessary for the state court. All right, so Mr. Haas is going to start us off by setting the table.
Thank you, Your Honor. This is a horrific accident. After I filed the lawsuit, Mr. Watt contacted me. We've had plenty of dealings throughout the years before, and we tried to really get to the bare bones of this case and hopefully make it easier through litigation. We stipulated after fairly long negotiations to try to limit the issues. I think that there was an agreement based upon the egregious injuries and really no defenses to liability that we would litigate the issue as to whether or not there was coverage under the Amerisher policy, which provided for $1 million in coverage if coverage applies. So we crafted a proposed stipulated order that outlines that if Your Honor and possibly the Court of Appeals, if either one of us decides to go that direction, determines that there is no coverage under the policy, there would be no recovery, at least per the policy. And if there is coverage, then Amerisher would tender the $1 million policy. I don't recall the specifics of the order, but I believe that the other parties other than Amerisher were dismissed without prejudice and allow for the refiling before the 3 years passed, if for some reason that this case went on for an extraordinary amount of time. That's the order, and I can get to the motion portion of it, but I think that kind of outlines what teed us up to this. Since that time, Mr. Watt has filed a motion for summary disposition. I've requested and previously provided a date for the deposition of an Amerisher adjuster. Since that time, I think it's been determined by defense, even though they can certainly speak to this issue, that it's really not relevant or necessary for the purpose of the C8 motion. And so Mr. Watt has a motion for protective order. I filed a motion to compel the deposition that was of the adjusters on the issue. And I think that's where we sit right now.
Right. And I have the stipulation before me, entered as an order March 19th, 2024. Let me check one other thing. That's interesting. What I don't understand is why would Top Hawks and Mr. Albana remain in the lawsuit?
So to be frank with you, Your Honor, we went back and forth so many times on crafting. I don't remember how it eventually ended up. Did they stay in and we just stayed the proceedings as to them on the third party portion of it, or were they actually dismissed? I think the thought behind it, what myself and Mr. Watt had discussed, and not knowing the absolute answer because this is the first time I've entered into such an order, is that maybe that they were necessary parties to the deck action, that they had to be parties to the case. I think their interest is per the deck action is pretty well protected anyways, because this is just the policy limits. It doesn't deal with any type of excess recovery against them in any event. But I think that the thought process was staying the case towards them, the third party negligence portion, until coverage could be sorted out, so they could be necessary parties to the deck declaratory action.
That's my recollection as well, Your Honor. I think we went through 7 or 8 revisions to this order over the course of several months.
Right. This is the fingerprints of the Home Office being involved.
I believe that's insightful, Judge.
We often operated with restrictions and limitations imposed by others. Okay. I understand the background. A couple facts I didn't pull out from the notes. I understand that plaintiff, Mr. Abdul Majid, he was a person working on the vehicle addressing the brakes. Is that right, Mr. Haas?
It is, Your Honor.
And the person who operated the 2009 Volvo semi-tractor, who is that person in relation to the plaintiff? Was he a coworker? Was he the owner of the vehicle or an operator of the vehicle? Well, obviously he's an operator, but is he the truck driver who used that vehicle?
So again, this is going to get into the summary disposition, I believe, and I'll use terms liberally as opposed to specifically or generally, I should say, because as we know, independent contractor has certain.
No, all I need to know is, was plaintiff employed at a facility that was a repair shop or something like that?
Oh, thank you. Yes, I can clarify that. My understanding, this will be a little further developed in the motions for summary disposition. Top Hawks is a trucking company, and they do long-term hauls, maybe some short-term hauls.
OTR.
Yes.
Over the road. All right. So
Yeah.
Top Hawks is an entity. That entity owns the tractor here at issue.
Correct.
Was the trailer attached to the tractor at the time of the injury?
It was, Your Honor.
Okay. Is that fact agreed on, Mr. Awad?
I believe so. I don't have any reason not to agree. Let me put
Oh,
that
all right. Yeah, I'm not trying to stick anybody, but bobtail versus pulling a load.
Yeah.
Was the individual working on the brakes at some separate entity or perhaps at the Top Hawk yard?
Yes, Top Hawk Yard, Your Honor. And the individual working, if I may provide a little bit more information or clarity, is actually the owner of Top Hawks.
Okay. So Top Hawks is a trucking company. How many, I mean, do they have more than 10? Top Hawks, have more than 10 tractors, if you know?
I don't know at this time, Your Honor. We're gathering all of that information with respect to responding to discovery by Mr. Watt, as well as responding to his motion for summary disposition.
Right. So the owner of Top Hawks working on the brakes is the person at the wheel, so to speak, a driver or the customary driver of this particular tractor?
No, I don't believe for this particular tractor. He did not own the tractor, and I'm talking about.
No. Is he? I'm not trying to get into ownership for more than 30 days. I'm not. That's not where I'm headed. All I'm asking is this a guy who hopped into a truck to move it, or does he have better than passing familiarity with the vehicle?
He is a certified operator of a tractor, and by my
But is he
understanding,
usually an over the road driver, or is he a guy who works around the yard?
my understanding of his is not long-term hauls. My understanding as to what he would do is that he would go to the when the long haul drivers are coming back, they don't necessarily, meaning Top Hawks, don't necessarily want to waste their time in.
Right, I'm familiar with the USDOT regs. I've got you.
So this individual, I believe, was going to a spot to pick up a load, bring it back, that it could be put onto another tractor or hooked up to another tractor for a long haul, by my understanding.
I'm confused. You've got owner who is
Top Hawks.
right, and then you've got owner of Top Hawks who is working on the brakes. So
Correct.
owner of Top Hawks is plaintiff, the person who was operating the vehicle at the time of plaintiff's injury. So Mr. Albana, what was his mission at the time of the injury?
My understanding is he was going to a site to pick up a load to then bring back to the yard where another long haul trucker could take it wherever he was going to go with it.
All right. Why was it that at the time he was going to make that movement, somebody was working on brakes?
Well, he went to go take off on the vehicle. It was a cold day. I don't know if we attached photographs, Your Honor, but it was November, I believe, and the brakes had frozen. So my client went under the vehicle to work on the brakes, and as the allegations go, that might no longer really be relevant for the purpose of this because liability isn't an issue. Before my client was cleared from under the vehicle, Mr. Albana went under the mistaken belief that he was no longer under the vehicle and went to go move the vehicle forward. I still don't think the brakes were working at that time because of tire marks, etc. Trapped his leg and essentially amputated it.
Right. November 21st, 2022 is the date of loss. So it wasn't a matter of a brake repair. It was just trying to get stuff moving.
Yeah, get the brakes unlocked or unfrozen. When Mr. Albana went to originally drive the vehicle, he was unable to because the brakes were seized up.
All right. Any further background you believe I need before we get started for what's before me today, Mr. Haas?
No, Your Honor.
Same question, Brother Counsel.
Mike?
I'm sorry, Your Honor. Mr. Hodgman just sent me a note, and I was reading that at the same time. No, I don't have anything to add to Mr. Haas's description of the event. That's my understanding as well. Is that Mr. Albana was just making local short moves of equipment for the over-the-road haulers.
So, I don't recall. Does Illinois have general demurrers, Mr. Beliche?
You mean limited emissions or some of this?
Well, you've got what? A Rule 56 motion under federal rules, right?
Correct.
You work in federal court as well?
Oh, yes, Your Honor. Yes, Your Honor.
Okay. So one of the peculiarities presented by this case is it's styled as a C8 motion. Unfortunately, over the years, many lawyers have confused C8 and C10 motions. Michigan Court Rule 2.116 subpart C8 provides that a court can grant summary disposition for the failure to state a claim upon which relief can be granted. Basically, what that means is, under Michigan's No Fault Act, you have to plead duty, breach of a duty, that the breach of the duty which constitutes negligence, that the negligence was a proximate cause of the damages, but in a tort case involving auto liability, there's the No Fault Act. So one must plead a serious impairment of an important body function, and I'll say yada, 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 or a permanent serious disfigurement, or death. If such a complaint were filed and there was no mention of a threshold injury, then summary disposition under subpart C8 would be appropriate because it fails to state a claim. A more simplistic analysis is if there were a tort that wasn't a tort, but rather a cookie. It's my soccer tort joke. And the elements of the cause of action called chocolate chip cookie included flour, eggs, sugar, what else goes in a cookie? If you didn't mention chocolate chips, then the C8 motion gets granted because you can't have a chocolate chip cookie without the chocolate chips in this hypothetical world. I'm sure there are other worlds that exist. So that's the framework of analysis. Typically, one is limited to what is written in the complaint. But under Michigan law, you can look beyond the extent of the complaint in certain circumstances. One circumstance would be if a document is attached to a pleading, and this is another error that not these two attorneys, but other attorneys make. A pleading under Michigan law is defined by the court rules to mean a complaint, including counterclaim, cross-claim, etc. An answer to such a thing, and in those rare situations where a reply is required to an answer, those are the pleadings. So if you have a claim based on a written instrument, and it's either attached to a pleading, or it's in the possession of the adverse party, and the pleading so states, then the pertinent parts of the instrument can be considered as part of the pleading for all purposes, including a motion for C8. So one question I had, Mr. Watt, and I've not fully digested the briefing in the motion for summary disposition because it's scheduled for, I think, June 27th.
Yes.
I'm somewhat at a loss for why it's a C8 motion. Generally, I would think that what you're casting about for is a C10 motion that is based upon discovery and facts. Why? Give me the thumbnail sketch on your C8 motion, Mr. Watt.
Yes, Your Honor. We basically have filed the C8 motion asking the court to review the pleadings only, which would be the complaint and the policy of insurance and the policy of insurance exclusions. We think the policy of itself, looking at its four corners, is sufficient for the court to make a determination as a matter of law. At least that's our position. Because at this point, we're only really talking about the declaratory action and whether or not coverage applies. So that's why we chose C8, Your Honor.
Right. And again, I'm looking ahead, getting a fresh new book, and then turning to the last pages. So perhaps that's somewhat, as my kids might say, sus or suspect. But give me a thumbnail sketch of the argument. There is no coverage for this alleged injury because
of the exclusions in the policy. There are four exclusions, and I'm doing this by memory, Your Honor. I don't have it in front of me. One is which is that the damages or that workers' compensation was the plaintiff's exclusive remedy. I'm sorry.
Exclusive remedy.
Exclusive remedy. Another was the coverage did not apply to harm caused by other employees, which is what we allege Mr. Aldana was. There was another exclusion that applied along a similar line, and again, I apologize, I don't have those exclusions right in front of me. I did not anticipate that for this motion, which is my fault. But there are 3 or 4 specific exclusions that we've cited in our motion in support of that contention. Is that as tragic and as bad as this accident was, there just isn't coverage available.
Give me a generic description of the type of coverage afforded by this policy.
The coverage would apply with a general liability policy that would apply to the negligent acts, or could apply to the negligent acts of the employer, Top Hawks. Top Hawks is the insured in this case, or the insured's employees in certain circumstances. So there is general liability coverage, and I'm going to struggle. So I don't want to go beyond and say that there was actually a separate auto policy because I don't recall that right off the top of my head. But that's what we'd be looking at. So if a Top Hawks driver caused an auto accident and injured another person, that person would then sue Top Hawks, and Amerisher would assume the defense and potentially ultimately indemnification. But because of the relationship here, Mr. Madrid's claims are excluded under the policy.
Okay. Is there any genuine issue as to material fact regarding whether plaintiff was an employee of Top Hawks as employee is used in the policy, in your opinion, Mr. Watt?
He was an employee, in my opinion, Your Honor.
All right. Under the tax code, was he an independent contractor, or was he a W-2 wage receiving employee of Top Hawks?
My understanding, he is the owner of the LLC. He formed the LLC and he's the owner. And I believe under the tax code, he's also considered an employee. Again, that's my belief. I don't have the site right in front of me.
No, just so we're clear, I appreciate it. I'm catching you more than a month early, but that's how I roll. So your client's position is that if the plaintiff had been walking across the yard, the trucking yard, and for whatever reason, Mr. Albano chose to be playing on his mobile phone, sending text messages. And for whatever reason, our plaintiff was wearing headphones or earmuffs or something, and he was run down. Your position is there would be no coverage.
Yes, Your Honor, that is correct.
Okay. So the arguments are there exclusions from coverage for a fellow employee. How is it that Amerisure has an auto policy that excludes an auto claim?
That's why I wanted to be careful about that, because I'm thinking that this is just a general liability policy. I just don't remember as we're sitting here speaking today.
All right.
If I may, it is a commercial auto policy. It's not a general liability policy. And
You're saying it's both, or it's a GL policy?
it's just a commercial auto policy. It's a commercial auto policy. I don't know if I need to increase the volume on my microphone.
Sure. No, you're a soft speaker, which.
Yeah, so I do apologize. Again, I know my status is that I'm not admitted in this court.
No, but you're a person with knowledge, so you're not making legal argument. You're not engaged in the unauthorized practice of law, UPL. You're helping us find our way to understanding what's going on. So this is not a general liability policy. This is a commercial auto policy. That's your understanding, Mr. Belici.
Oh, yes, Your Honor.
Okay. And the commercial auto policy, however, has certain exclusions and potentially exceptions to exclusions, right?
Correct, Your Honor.
All right. Did Amerisure also write the workers' compensation policy that exists on site, assuming one exists?
It does not, Your Honor.
One does not exist.
All right. So there's no workers' comp policy. Does discovery indicate whether or not the plaintiff received an IRS Form W-2 or distributions as a member of a limited liability company? Do you have that answer first, Mr. Haas?
Your Honor, again, we're gathering all of that for the.
No, it's okay to say no if you don't know.
But my general understanding, I certainly don't want to acquiesce this point for any type of permanent purpose. But I do like to be frank with the court and argue that issues that I believe are truly issues to be argued and concede on other ones. I think Mr. Watt may be correct that as an owner of Top Hawks, that and again without any commitment because we're still researching it, that Mr. Majid might be deemed to be an employee of Top Hawks. I believe that may be correct based upon his ownership of the company. But with saying that, I don't know if he got W-2 or 1099 at this time. I think I have that at the office, but because of my Zoom link, I can't link into that portion of it.
No, you're fine. Do you have a sense one way or the other on that issue, Mr. Watt?
I would agree with what Mr. Haas says. I do think that I haven't seen Mr. Majid's tax documentation or his business documentation yet, but my research tells me that he is an employee as the owner of the LLC.
No, my question was different. I was asking whether there was a Form W-2.
Oh, I do not know, Your Honor.
All right. Okay. Right, so I'm looking at the policy exclusions. Quote, any obligation for the insured or the insured's insured may be held liable under any workers' compensation, disability benefits, or unemployment compensation law or any similar law. Bodily injury to an employee of the insured arising out of and in the scope of employment by the insured, performing duties related to the conduct of the insured's business. Fellow employee. Okay, I feel comfortable with that. Let's do this. We'll argue the motions. I hear motions in the order in which they were filed, unless, of course, I see a different reason. That means that the May 6th motion, plaintiff's motion to compel deposition, is the leadoff, followed by Merish's motion for protective order. There is some complexity here because I mean, I suppose I'll be rather blunt. Well, no, I'll ask it this way. Mr. Watt, are you aware of any case under Michigan law interpreting the same or similar exclusions under the same or similar facts? That's okay if you're unaware of one.
I'm unaware of one as we sit here.
All right. One of the issues may be whether or not such a policy exclusion is void as contrary to public policy. Sitting here today, I simply don't have enough information to know that. We're a little bit backwards. I appreciate exactly why. It would be the preference of Amerisure not to permit the discovery because once somebody starts rattling around, they might find something. So I get that. That's why law enforcement needs either your permission or a warrant or exigent circumstances to go into your home because you never know what somebody might find. So I understand the logic. So the pro hoc vice process under Michigan Court Rule 8.126 is not terribly unique. I would propose maybe we handle that first. And I'm sure that means I'll be the only one ready to roll on that. Mr. Beliche, I'll place you under oath because you're not an admitted Michigan attorney. Raise your right hand. Do you solemnly swear or affirm that all of your statements on the record today in response to my questions will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
May lower your hand. Your name is Anthony Beliche, Balice. Is that correct?
Correct, Your Honor.
Are you currently an attorney licensed to practice in the state of Illinois and in good standing as it relates to your membership
Yes, I
in
am.
the State Bar of Illinois?
Yes, I am, Your Honor.
All right. You're with the Emerson, EMERSON, ampersand, Elder, ELDER law firm in Chicago, Illinois.
Yes, Your Honor.
All right. How many times have you sought admission to the State Bar? I'm sorry, admission on a pro hoc vice basis in Michigan over the past 12 months?
One other time, Your Honor.
All right. Was that request granted?
Yes, yes, Your Honor.
Do you recall what court?
I believe it's Wayne County.
Would it be the circuit court, the probate court?
I was the circuit court, Your Honor.
Do you recall the judge's name?
It's Judge Valentine, I believe.
Well, she would be Oakland County Circuit.
Yes,
Court.
Oakland County. I do apologize. It's
Sixth Judicial Circuit of and for Michigan. All right. Although I don't know whether we call it admission pro hoc vice, I believe they've amended it and it's now referenced as a motion for temporary admission to the bar. Have you ever been disbarred or suspended in any jurisdiction?
no, I have not, Your Honor.
And your motion for temporary admission is supported by attorney in good standing. Let me pull that document back up. The motion, of course, was supported by Mr. Watt. Mr. Watt, you made due and diligent inquiry into the facts and circumstances of Mr. Beliche's qualifications as it relates to the motion you filed for temporary admission.
Yes, Your Honor.
All right. Let me click back over here. There is certain information omitted that will need to be provided. Let's go through the procedure. An out-of-state attorney may be temporarily admitted to practice under this rule for no more than 5 cases in a 365-day period. Permission to appear and practice is within the discretion of court and may be revoked at any time for misconduct. The practice or the process is as follows. First, you must be associated with a Michigan attorney, and with Mr. Watt's assistance, you've got that covered. You've filed the appearance and motion, Mr. Watt. What we do need is a current certificate of good standing issued by I think it's the Illinois State Bar Association. I don't recall. Was that document attached to the motion papers?
It should have been attached, Your Honor. If it wasn't, I do apologize. But
let me look. Here's affidavit A. Oh, and here's the reference to the 6th Judicial Circuit of Michigan of and for Oakland County. Right. I don't see a certificate attached. That has to be submitted. Bear with me. So do jot a note. You'll need a current certificate of good standing issued by the Illinois State Bar Association. There needs to be a document supplied by the State Bar of Michigan showing that the required fee has been paid. Let me check your affidavit briefly. Well, your affidavit does mention a certificate of good standing in Illinois attached as Exhibit A, but somehow it was omitted. So that's just a matter of finding that.
I know we attached. I apologize if it was not attached. I remember ordering it from the.
Oh, no. I'm quite aware of my state of not being perfect, but if I become perfect, which can happen, you all can watch out. The affidavit does verify the jurisdictions in which Mr. Beliche has been licensed and has sought licensure. The jurisdiction where he's presently eligible to practice. It indicates that he is not disbarred or suspended in any jurisdiction and is not the subject of any pending disciplinary action, and that he is licensed and in good standing in all jurisdictions where he's licensed. Let me hop back over. Okay. Oh, one other thing that needs to be fleshed out. And what I would suggest you do is you have a remarkably similar affidavit prepared. You get a current certificate of good standing in Illinois. I don't quite recall. There's a link on the State Bar of Michigan website that says how current they need to be. And you do need to state, oh no, here it is. I'm familiar with the Michigan rules of professional conduct, Michigan court rules, and the Michigan rules of evidence. So that takes care of that box. I'm turning back to the body of the motion. The motion does indicate that Mr. Watts has read the accompanying affidavit of Mr. Beliche, has made reasonable inquiry as to the statements therein, believes that the same are true, and agrees to ensure that the procedures of MCRA .126 are followed. No counsel of record has objected. I assume you have no objection to Mr. Beliche joining the fray. Am I correct, Mr. Haas?
I have no objection, Your Honor.
All right. The professionalism is always appreciated by all judges everywhere. Right. Addresses and email addresses. Let me double check that, which should be the easiest part to satisfy. There's your address. There's your email address, even a telephone. Do indicate on all papers, obviously, Mr. Watts, that if the motion is granted, that he should be identified as co-counsel having been granted temporary admission pursuant to MCR 8.126 by order dated, and sticking the date of the order. For my purposes, that's the absolute easiest way. If I get hit by a bus, knock on wood, and there's some successor judge who comes in behind me, that way the caption will always make clear your role. Okay. I don't know if we have a standard form order prepared by, or that SCAO has established, but do present an order. I can make a conditional ruling on the motion. The motion is granted under the following condition precedent or precedent, depending on who you had for contracts at law school. There must be presented the Illinois State Bar Association current certificate of good standing, as well as the document supplied by the State Bar of Michigan showing that the required fee has been paid. Once those two items are completed, then council can submit an order, and upon the happening of those events, then the motion will be granted. Is there anything further you feel I should cover in this aspect of the ruling, Mr. Watts?
No, Your Honor.
Or I just pluralized you.
That's fine.
There's only one of you.
There's only one of me. Yeah.
All right. So additionally, congratulations.
Thank you, Your Honor.
All right. So on to the matter at hand. Next up for hearing is your motion. You don't have to go into great detail. I've got an understanding. Perhaps you could focus on the response by Mr. Watt to your client's motion, Mr. Haas.
Certainly, Your Honor. I did file a reply, which I think I did respond to that.
But again, the reply is for a 7-day motion. That's unusual, but proceed.
Okay, thank you, Your Honor. I think that I did address that. I will just highlight, I think it's hopefully a relatively simplistic motion and issue. I will just hit on my couple of points, and if Your Honor, of course, has any questions, I'll respond to the best of my ability. I don't disagree with Mr. Watt to the extent of this. It is a C8 motion. However, it has, the complaint seems to be, or some of the issues seem to be changed a little bit, that we actually have to litigate in the case based upon the stipulated order, which will focus upon whether or not there's coverage under the contract. So all of those other issues as far as negligence that might require greater factual development may not be there. But I think for even under the question as to whether or not there's coverage, for reasons I mainly say in my reply brief, I do think that there's not a basis to quash depositions or order that no discovery in this regard be had. There is liberal broad discovery in Michigan. Just a couple of things regarding the contract or contractual terms. If the contractual terms are not clear, factual development may be necessary to determine the intent of the parties. That would be a factual issue, I believe, that I'm able to go into, at least as a preliminary matter. And with all respect, Your Honor, and to defense counsel as well, even if it turns out in doing a deposition, I was very specific as to who I wanted to depose, that ultimately that's not admissible later, relevant later by some determination of the court, that shouldn't necessarily preclude me from exploring those areas as well. The other area is that contract should be interpreted according to the ordinary and plain meaning of the terms. That could be an area that I can go into with defense or with the adjusters as well, or the individuals that claim that there's no coverage that applies, and ask them regarding their understanding. Ultimately, Your Honor is likely going to have to make your own determination based upon case law or what you believe to be a plain, but it could be relevant if they acquiesce or agree. Well, yeah, it could be interpreted that way because it would be construed against them. So we should be able to cross-examine on the terms of the contract, how and when they are applied, when coverage is afforded, and when coverage is denied. I did cite a case of Anderson versus Progressive Marathon that goes into not the exact issues, but similar issues that dealt with the claim or contractual claim. And the defense argued, well, threshold injury is a legal determination, whether or not it meets for the court and or for jurors. What difference does it make if you ask the adjusters regarding their opinions in this regard, and the court clearly held it is broad discovery, and you should be able to ask those types of questions. So I don't think I'm asking for anything special, just for a deposition. I was given a date previously, I believe it might have even been for today, May 21, and since then I think the thought process on it did change. But I still like an opportunity to depose Don Schaefer, who wrote the denial, as well as anyone else that they want to appoint for the deposition notice that I attached to cover those issues regarding coverage and the terms of the exclusions that they believe are applicable to this case.
And the proposed opponent is DAWN, last name SHAFFER.
Correct. And then I was also requested to provide a deposition notice for representative identifying certain issues. I attached that as well, because again, I don't know, Don wrote Ms. Schaefer, I should say, wrote the denial letter. So she has some knowledge, but I also had requested an individual representative who I can read them, but I did attach it as Exhibit A, the deposition notice, which covered 4 different areas of the coverage and the terms that I wouldn't want them to be able to comment on. I wouldn't know who the individual is that would be able to testify in that regard. So Mr. Watt asked me to provide such a notice.
Right. And that's typical under the court rules. The federal rules are of the same moment. And probably the three of you have figured out that even though the motion for protective order is not up today, that we'll be addressing it because it's the reverse of the coin that's being tossed in the air. That's not how I rule, but how if I rule one way, we go one way. If I rule another way, we go another way. Talk to me. Anything further you'd like to say about the motion for protective order while you're on the grill currently, Mr. Haas?
No, Your Honor, I believe we might be in the process of filing a response to that because I think it was up on Friday. As Your Honor indicated, I believe it does go into essentially the main issues. I don't believe that there would be any compelling reason to grant a protective order for essentially all the same reasons that I cited and indicated in my motion and reply brief up for today.
Right. I figured that would be your position. Let me hear from Mr. Watt. You can handle these together if you want, or you can start with the motion to compel and then follow up the motion for protective order.
Sure. I think I'll start with the motion to compel because that's the one I'm most versed on. And I think the argument's pretty straightforward, and we've kind of been kicking around all day or all morning. So this is we have filed a C8 motion. We're not taking a position that the plaintiff would be not entitled to discovery at all. The position is we were able to move this case along rather quickly. We've limited the issues. We believe we have a legal issue for the court to decide based on the pleadings in and of themselves, and that we were given a pretty quick hearing date, the end of June, such that it made sense to just go ahead and have our C8 motion heard. If we're unsuccessful, we would still have time for discovery. I apologize, I don't have the scheduling order right in front of me, but we would still have an opportunity to do all of the discovery that that plaintiff is seeking. So we were looking at it for more trying to control the cost of litigation, judicial economy. Let's get this legal issue resolved. Win, lose, or draw. Then, if we lose, we'll move on to the next issue, which is the deposition. So I think that was the primary intent. Obviously, kind of merging into the issue for protective order. I think my protective order was, again, not to take the position that they would never be entitled to a deposition under any circumstances, but more in terms of getting our C8 motion heard. Now, we did address some issues about the scope, I guess, of their request to depose our Amerishire representatives, to the extent that they were going to ask for legal opinions from those folks. Again, I think a lot of those type of issues would be handled by through objection at the time of the deposition, if and when it actually goes. So I guess that's pretty much our position at this point. We're asking just for the court to in essence stay any depositions till hearing on our C8 motion, and then we can regroup after that if necessary.
All right. I assume you have nothing further, Mr. Haas.
No, the only thing I would like to add, and maybe it hasn't made it into my books yet, but I'm just realizing, as Mr. Hodgman indicated, their summary disposition is that the hearing date is on June 27th. I do have I'm going to be out of the country on a pre-planned trip with my wife on.
Well, let's pause.
Sorry.
I hate to hear the lawyers tell me about their fancy trips.
Oh, well,
just because it makes me feel bad being a public servant. I'm kidding. But obviously we would accommodate. I may have a reputation for being a stickler about a lot of things, but you all need to be able to have time with families. And so all I'll ask is, it somewhere cool?
It is.
Thumbs up. All right, that's all I need to hear. Do children get to enjoy this, or is this a mom and dad type thing?
Usually they do, but my parents are back from Arizona for the summertime, and they've agreed to watch them.
Wait, did you say they foolishly agreed to watch them?
Some of them, you must be able to read my mind a little bit. I'm hoping that they'll still watch them after that.
No, we will give flexibility. All right.
I'm back on July 1.
Let's hope the only fireworks are not caused by the kids, figuratively. All right. Anything further, Mr. Watt?
No, Your Honor.
All right. So the workup done on today's efforts, initially by Mr. Hodgman, then I get to throw in my 2 cents. He still allows that. There is a fair amount that has gone into this. The law is rather nuanced and complicated in certain areas, and respectfully, this might be one of those areas. Specifically, an employee or covered under workers' comp, those are factual determinants that must be ascertained. Maybe, maybe not. If I'm ruling on a C8 motion, I will be ruling only on the law and not the facts. About 95% of the C8 motions filed that I hear, I deny, because they're written by lawyers other than Mr. Watt, who don't appreciate the difference between a ruling as a matter of law as opposed to a C10 motion, which was a ruling assembling all the facts that are not reasonably in dispute and accepting all the well-pled allegations in the light, although the appellate court say a light, but the light most favorable to the non-moving party. And potentially, this might transmogrify into a joint C8 and C10 motion. It may be after discovery is done that a second dispositive motion might be filed by Mr. Watt, and that's okay. I am granting the motion filed by plaintiff. I'm allowing the deposition of Dawn Schaefer and the deposition of the person or persons who are able to respond to the areas identified. I ask counsel to work together, as I expect in all cases, so that there's not an array or a panoply of persons that have to be produced. The purpose is to flesh this out. Your one risk, Mr. Haas, is that maybe they'll come up with another basis for summary disposition of the claims against the carrier here, Amerisure. But as a practical matter, that is what it is. Obviously, I'm moving the hearing on Friday on the motion filed by Amerisure seeking a protective order. It's, as my JA indicated, rather part and parcel of the plaintiff's motion. I do want each side to be very careful. Again, I've not gone through the dispositive motion in detail, but, oh gosh, what's the name of the case? Keywin, K-E-W-I-N, I think. Maybe it's Kerwin, but I think it's Keywin versus Mass Mutual Insurance Company. Take a look at that case, each of the three of you, and give it a thought. It may be prudent to plot a more careful path because if suddenly I'm faced with an amended complaint arguing that Top Hawks was sold a policy of illusory coverage that has other issues that might be implicated, I promise you I'm not trying to make this case more difficult. It's bizarre to me that one would purchase a policy that has such tremendous holes in coverage that Top Hawks would be self-insured for certain types of claims when their business is the business of trucking, and the policy that lacks areas of coverage relate directly to a primary mission of the insured. Again, I offer this not as a pre-ruling because I just don't have enough factual information, but I suggest that that you give that consideration. The Truckit issue, Mr. Haas, was a title to the name of Top Hawks LLC, if you have that information.
I believe it was, Your Honor.
All right. And then Mr. Hodgman advised me through the miracle of direct messaging that there also was a motion filed as it relates to Donald, middle initial E, last name Elder. Also has an affidavit attached. And no certificate, no current certificate of good standing is attached to that affidavit. I don't see a copy of essentially the, I don't want to debase it and call it a receipt because it's the state bar, so they do more than that. But there is not the document that is required in a motion for temporary admission that contains here it is, the document supplied by the State Bar of Michigan showing that the required fee has been paid. Do you have the same argument in support of this individual, Mr. Watt?
Yes, I do, Your Honor.
Would Yogi Berra say it's like deja vu all over again? Not exactly, but kind of. So similarly, I'm making the same ruling as it relates to Donald E. Elder. So once those are done, then you may submit an order. Do indicate in the proposed order, and you should probably do two separate orders, one for each individual. Make sure you indicate that the documentation has been presented and filed with the court. So the hearing on Friday won't proceed because it was handled today. Defendant's motion for protective order denied for the reasons stated on the record and include these words by the court. I think we're going to need to schedule a new date regardless because it seems like Mr. Haas has cleverly planned his vacation so as to avoid me to the maximum extent he can. Because when he arrives, I have departed, but I don't take that personally. So what I think we're going to do as it relates to that, and Mr. Hodgman having obligations as well, is we might be looking at early August for that dispositive motion hearing. The good news is that'll give you plenty of time if there has to be a second motion. And the goal here is for me to understand well the issues, because it does seem likely that whomever prevails in the trial court might be seeking relief in the Court of Appeals. I know a bunch of those people and hate to be embarrassed and try my darndest to get it right. The other, well, so you've got, you can put the cross motions ruling in the same piece of paper, give the title of each moment, throw in a subordinate clause following comma, which was filed on, and then identify them as plaintiff's motion and defendant's motion. And plaintiffs, and for the reasons stay on the record, again, the magic words by the court, plaintiff's motion is granted, defendant's motion is denied, and then the hearing or the orders on the temporary admissions should be in 2 additional orders, so 3 orders all day. Have I ruled on everything before me today, Mr. Haas?
I believe so, Your Honor.
All right, and do you agree, Mr. Watt?
Yes, I do, Your Honor.
All right, and there's one other thing I wanted to touch on briefly. Here we go. My apologies. Is PIP being paid, if you know, Mr. Haas?
It is not, Your Honor. That was also denied by Amerisure because he was not a occupant of the vehicle at the time. So that went through, I'm sorry, through the Amerisure policy, he has an assigned claims case for PIP benefits, which is being handled. I can't remember the assigned carrier, but it was assigned.
But if I may, is that being paid or is that in litigation?
It was, they paid out all of the medical, the 250 cap. There's litigation because the 1 year came up before they paid the wage loss. So that's in litigation currently. My guess is it'll be resolved in short order once all the documents are exchanged.
But the answer is yes, there is a lawsuit. Which was filed first, this case or that case?
I can tell you in 1 minute, Your Honor. I'm pretty sure it was this case.
Right, because if it's a PIP case, everybody likes Wayne County for the PIP.
Yes, that is true. Let's pull this up. Pleadings. So this complaint was filed, I have 9/28/23, and then the PIP one was filed 12/18/23 and was assigned to, I'm sure I put in there that another action was pending. I did. And it was assigned to Your Honor.
All right, good. Not good because I want more work, but I'm going to revise at some point. Mr. Hodgman and I are going to convince the powers that be in the court to give attorneys additional searchability, 2 words, on ascertaining information on the Register of Actions online. We should load in for every provider case, each patient, as well as the date of motor vehicle accident, because often we'll have medical provider cases and DEC actions and an individual's PIP claim and individual's tort claim scattered throughout. And they really have to be before the same judge pursuant to same transaction occurrence. And we have a special docket directive, 1 accident, 1 judge. All right. That sounds good. I wish all of you luck. Mr. Hodgman and I will be looking at what to do about future dates and give you a new hearing date, probably tweak the, well, make it so that if you want to have more than just the 1 motion for partial summary disposition, that is defendant Amerisure's motion, that we can accommodate other motions and just do a very good job of making sure that to the extent a request is made under C8, that all the facts are segregated from argument. All right. Anything else today, Mr. Haas?
No, Your Honor. Thank you for taking the time with us today.
Mr. Watt?
No, Your Honor. Thank you.
Mr. Belici?
No, thank you, Your Honor.
All right. We'll stand in recess. Have a good afternoon. Thank you.
Thank you, Your Honor.
as we have time, I'm going to shut down the YouTube.